Good afternoon, ladies and gentlemen. Thank you all for attending tonight's event, the Qualified Immunity for Officers and the Current Racial Unrest. This event is sponsored by the American Constitution Society alongside the Black Law Students Association and Hispanic Law Students Association. Today, we have two established and prestigious panelists today. First, we have Professor Murphy, who is an associate professor at the University of Arkansas School of Law, and Dean Gallini, who is the Dean of Willamette School of Law and former professor of law at the University of Arkansas. Would y'all like to just say hey to everyone first? I think everyone's here.
Well, it's great to see you, Byron, and I see a lot of familiar friends and faces, and it's just great to be with all of you and have an opportunity to reconnect and talk about a really important topic. So I'm looking forward to the discussion and to your questions.
And Professor Murphy? I think we may have to wait 1 second. I see she may be having some issues, but I think we can go ahead and get started and just let her join in as the process goes. And so the first question is, what is qualified immunity and who does it protect? For you, Professor Gallini.
Yeah, it's funny, I told when we were chatting to get ready for today, I warned Jonathan that, and as many of you may know, I am not a qualified immunity expert, and I'm hoping we'll get into some of the discretionary policing issues that go with it. But that said, I'm happy to take a run at it because, as all of you may recall, I'm more sort of criminal focused, and qualified immunity being a civil topic that, in short, gives officers civil immunity for, and essentially performing in the line of duty acts that would otherwise be render them civilly liable. And of course, as we all know, that is prominently in the news, and for good reason, because we've got a question about whether officers who act within the scope of their line of duty, if they should indeed remain immune from civil liability. And I guess I would add that, it's interesting to think about on this topic. When we think about suing officers singular, it doesn't sort of get at the heart of what might be in the plaintiff's mind, right? At least as I gently step out of my criminal lane, I would imagine the concern is really about thinking through departmental liability at a broader brush. And so, a lot of the national conversation reasonably has been around the individual qualified immunity for officers singular, but I'm certainly more curious about, what kind of conversations could we engage in to think about departmental liability to really push reform. And I guess that's where I would close on this answer, which is, even if we get over the hurdle of individual officer qualified immunity, is that enough to push reform? Because don't we want policy-based reform at a broader level that doesn't apply just to the individual officer?
Thank you. Professor Murphy, are you there now? I see she's unmuted. I guess we can just keep going. So based on what you do know about qualified immunity, what are some of the positive aspects of qualified immunity and ways or reasons that we should keep that within our society?
Yeah, I guess my vantage point on this question is there are a couple competing considerations to think about. So number one, if we eliminate qualified immunity entirely, and let's live in a world where we really are focused, to go back to the answer I gave in the first question, we really are focused on the specific officer. I think we want to be justifiably concerned about the extent to which, if we start opening the floodgates, so to speak, to civil liability for officers, who's going to want to do that job, right? And so the brain drain concern, I think, is a very real one. And so I would put that kind of front and center around, well, if I'm doing my job and I get sued for it, and not only do I lose my job, but I lose whatever savings or whatever financial stability I had, maybe I don't want to do that job. And so that's sort of what I mean by the brain drain question. I think the other thing we want to think about is deterring. I know that we are focused on really meritorious examples of getting rid of qualified immunity or maybe reducing it, but lost in that narrative can be the reason it started to begin with, which is discouraging what might be ordinary complaints from rising to the level of what the civil law is designed to respond to. So I guess, the plaintiff who is litigious is the other, kind of the other side of this that I would have us pause and kind of think before we eliminate or reduce.
And so what would be some of the negative aspects of it as well, which is kind of counter to what you're saying?
Yeah, in other words, what's bad about keeping it, right? I mean, we've got this huge hurdle where if we view, and this is a big if we view civil law as having a role in deterrence, which is a little bit like giant shrimp, right? Because we usually think about criminal law in that role. But if we view civil law in that space, then I think we should be worried about its ability to do its job if we stand up this significant hurdle to allowing plaintiffs to seek some type of financial recompense. And I think the other thing is to go back to this point about departmental training. Departments know that, right? Which is why, to pull from a headline, we saw a department get out in front days ago of the civil liability question by settling for $12 million with Breonna Taylor, and that was directly in response to this immunity question. So, to me, what we do know, however you individually come down in your own philosophy, what we do know is what we have is not necessarily finely tuned to weed out the meritless cases while promoting the evolution of policing.
And so with that being said, do you think that qualified immunity has an actual impact on the field interactions of law enforcement with humans, as well as departmentally and nationally as well?
It's a hard question because it causes us to really try to get out of the weeds in some ways, because I would give a different answer to this group being at least conversationally familiar with the concept. But what you're really asking is, what does the average citizen know? And then I think what you're also asking is, what does the average officer know? And I think before we answer that, we've got to put two kind of different lenses on this answer. One of which is before 2020 and now, right? Because what we've seen is a fundamental shift in the national conversation. We were trading some emails, Jonathan and I, about, if there's a positive out of the national conversation, it's that we are talking about what otherwise would be nuanced topics more over the dinner table, so to speak. So I'm not sure if that perfectly answers the question, but it's at least, I think, a silver lining to all of this.
And so qualified immunity technically is an affirmative defense. However, it's not like the typical affirmative defense in a civil case where the burden's not on the officer or someone like that to actually assert this defense and have to prove that this defense applies. So with qualified immunity, technically the plaintiff has to rebut this presumption. And so what is required on the plaintiff to rebut that presumption going forward? And what are ways that we should tweak this, if we should tweak it at all?
You're asking really good questions. This too is a difficult one, because we're going to have to show as the plaintiff that the officer's actions were outside of the officer's responsibilities, right? The line of their professional responsibilities, which takes both a really broad framing, community service, protect the public, and then a really narrow framing. And it's the narrow framing that I think gives me pause, at least, because that narrow framing might be tied to departmental policy, or what gives me still more pause is the absence of departmental policy, which then creates this essentially presumption at the departmental level of complete police discretion. And so when I think about what do we have to get over, I see it in three ways, right? I see it in this broad-based discussion of what we expect of police, then the more slightly narrow framework of the departmental policy, and then again, that more nuanced framing of the absence of. And I think it's appropriate for us to be thinking about regions here too, because Johnson, Arkansas police may have a very different framing of how they interact with use of force than downtown New York City, right? So when we have this policy conversation, we really have to be thinking about the region and the citizens that each department serves. So I think I also worry that first positive is having a national dialogue and a conversation just like this one really is, that it's not, to go to the latter part of your question, it's not as finely tuned as we might want, because the broader the conversation, the harder it is to have a more sophisticated, detailed conversation about what each individual geographic citizen base might view as problematic in their policing. As to the how to fix it, the very back end of your question, what can we do? I think, as many of you know from the privilege of having many of you in class, you know that one of the things that we've talked a lot about is this idea that police are, to my mind, the only profession where the lower you go down in the hierarchical chain, the higher the discretion. And the only thing that constrains that discretion is internal policing policy. But the troubling thing about that observation is that the people who set that policy are the police themselves. So when we step back, what we see is a troubling narrative around the police policing the police. And then if there is a concern, the police police that, right? And if it gets to the criminal side, it's the prosecutors who the police report to, who hold them accountable. So I think there's a lot more to be said here, but I guess, and I'm happy to dive more into the weeds on this, because I think there really is a lot to be said, really tugging the thread of, how do we address this? But I would close, just in the interest of brevity, by saying, trying to bring into the national conversation even a basic understanding of the role that police training and policy plays in the qualified immunity space. Because to tie the answer all the way together, the way that we police in one space of the country is not the way that we police in another space of the country.
And so with that being said, how training is different based on location and things like that, should we make a more national standard to how we should police, or should we continue to give up discretion to each geographic location, such as maybe Arkansas polices this way and things like that?
There's a lot we could do, an hour on each of these topics. So I think it's hard to not bring in the role of the judiciary into this, right? Because when we say that policing develops policy, that policy stems from the law, right? It's an interpretation of the law. And so now we start talking about sources of law, and we talk about the evolution of local statutes, local ordinances, and the interplay that has and the pressure points that puts on the police. We might add in reported appellate case law. And then, of course, at the top end of the chain, as everybody knows, we have interpretations of US Supreme Court decisions, which PS makes the nomination conversation all the more important to fold into this. So it's really hard to briefly answer that question, but I think there is a national standard that I would call a baseline of expectation. And so the easiest example in my mind, and keep in mind I'm speaking only for myself, is when we think about the use of force conversation. If we could have a more nationalized understanding of when it's appropriate and when it's not, and we look back, and I'm anxious for Professor Murphy's take on this, but I look back and I view Tennessee v. Garner as dated law. It's really hard for me to think about that opinion in 2020. And so the place that I would start, at least, and you all have been listening to me quite a bit, so I'm going to pass the virtual baton and go blue to Professor Murphy in a moment. But the place for me to start is the use of force conversation at the constitutional level. And we can loop back to talk about how that filters into day-to-day policing.
Sorry, I've had so many technical difficulties. I think my computer was like, you've been in too many online meetings today. We need a break. So decided this was the break. And so we had to have a stern talking to my tower. So I apologize for that, everyone. I apologize that I'm playing catch up, but as far as the use of force, one of the things I will talk about is from a practical standpoint of how it's reported and what that looks like. I'm not going to talk about the legal stuff. I'll leave that to Dean Gallini, who's much more versed in it than I am. But I will talk about it as far as what does it mean when we use of force and how we can affect change, which I think is the bigger question. So when I talk to a lot of students, and when we have these cases in the clinic to a certain degree, searches, stops, stop and frisk, whatever interaction with the police, any traffic stop, any of what you think about, one of the things that is problematic is how departments code this information, process this information, and then use it to justify funding, to justify change, to justify things to the legislatures of the states or their localities. If you want to see change as far as use of force, you start from the ground up. I'm a fact person. I'm a litigator by nature. Everything is driven by the facts. And one of the things that has to happen is work with your city council. They control parts of the department. They're your local police departments. There are over 18,000 law enforcement divisions in this country. 18,000. They can be sheriff's offices. They can be individual little municipalities. They can be your city police. They can be the state police, and on and on and on. And you have certain police departments that overlap jurisdiction. So that's something. So, you know, when you think about, if you just think about Washington County, let's just take Washington County. You got the sheriff's office, you got the Fayetteville Police Department, you've got the Johnson Police Department, okay? You have the state police, you have the highway patrol. That's 5 right off the top. And then when you start traveling, you get more and you get more. So did I freeze? Okay, I'm all worried about it. So when I say look at it from the ground up, if you want to challenge use of force, understand what you're talking about. Get the standard operating procedures of your police department. Understand how they define it. That's what officers are trained on. Understand what you're talking about. Then look at the situations in your community and start working with your city council. Start engaging. This is an action, because I will tell you legally, in my opinion, with qualified immunity, it is damn near impossible unless we have congressional action. Because we're not gonna, Dean Gallini's right, we're not gonna get anything from the court now. We're just not. It is where we are. So we need action legislatively, and that can happen. That can happen. Let me take you for an example. I'm from Detroit, also affiliated with the Big M back there. There was a lot of problems with the Detroit Police Department. My father was a Detroit police officer. I grew up around law enforcement. I watched that office go through massive change and how it used force and how it interacted with a community that was largely people of color. And it has changed. And it also was changed because the prosecutor demanded change from the police department and started prosecuting officers who acted outside their acceptable use of force, even if they lost cases. And that's the hard part. And we'll get to Breonna Taylor in a second. And we'll also get to Mike Brown and that grand jury issue. But the idea that the prosecutor's office for Wayne County, which is Detroit, went after those officers, it changed things. I'm saying is you guys have power to make change. Who you elect on a local, state, city council has a lot of power as far as how you are policed within your communities. Okay? I know a lot of times we want to look to the courts as our salvation. We're attorneys, that's what we do. But I would like to also suggest that we do a political change, meaning get involved, understand what you're talking about. When I am challenging a stop for one of my clients in the clinic, I have the entire Washington County Sheriff's Office manual in my office. And we know what they do and we know what they're not supposed to do. If you have a question about what the University of Arkansas Police Department does, FOIA their department manual and have a conversation. Your students, you have a right to it. This is what I'm talking about. If you want to understand how things work, you have to know how they work. You have to find out how they work. And don't forget, you're all citizens of the state. You have access through freedom of information, the state freedom of information, to ask for a plethora of information about how policing is done. Everything is local. So I understand, and I have my own issues about qualified immunity and why it is a mess that the court has made. When the court has closed an office, when the court has closed an avenue, there are other avenues to you, and you have to be creative. One thing that I tell my clinic students is the law does not limit your creativity. You're going to have to use the law in different ways. If you want to be, run for office. If you want to affect change, if you want to change, then get involved. Get on the city council. Get in policing boards. Those are the things that I think make a considerable difference where you live. And then you can go from there. But use of force is something that you have to understand how it is defined within a department and then start working from there.
Thank you. So Professor Murphy, we talked a little bit earlier about what are some of the negative aspects of qualified immunity. And I see you have some strong feelings about that. So we'll go ahead and let you talk about that a little bit as well.
It sucks. It's incredibly hard to get past that affirmative defense. And the court has made it nigh to impossible for the circuits to truly give relief in even the most egregious cases. I mean, things that would get would literally any of the most conservative judges who would potentially say this is clearly a 4th, 5th violation and I'm suppressing it. You would challenge on a 1983 action and run into a brick wall that is almost it's impenetrable. The standard is so lenient to protect even the most egregious conduct. Situations where officers have detained people for hours on the side of the road, fine. Even though under 4th, 5th Amendment on a prosecution or a search and seizure, that is grounds in and of itself for motion to suppress, motion to dismiss, gone. Most prosecutors wouldn't even try it because they know it's not going to go. But if you are challenging civilly for the violation of your constitutional rights, you have no mechanism anymore. So that is what I have as a problem of qualified immunity. It is almost, the court has made it so forgiving to the extreme that it is very difficult in situations to get relief, even in situations which you would never have a prosecution. And I find that offensive, to put it mildly, because if you can't prosecute someone for a constitutional violation, but then saying they have no restitution for that same violation, that is a disconnect that we as a society should not allow. I think that answers your question.
Thank you. And so,
Aaron, can I say
just go ahead
on that? Because not only do I agree with that, I would just also point out that on Professor Murphy's point about the prosecutor wouldn't take the 4th and 5th Amendment and be suppressed. I just wanted to emphasize, what if there was no contraband found in that traffic stop or in that interaction, right? There's still a rights violation. And we've seen tons of Supreme Court jurisprudence say, hey, we don't need the exclusionary rule because we have this other mechanism. But as she points out, we don't. And so it's really kind of this double impact where if I don't have the exclusionary rule because factually I don't have contraband on me, then practically I don't have a civil remedy and I don't have a criminal remedy because the exclusionary rule is inapplicable. So it's really sort of that double-sided concern.
So going forward, how can we remedy this situation as we go to our legislator? What type of laws should we put in place to help give some type of restitution to people whose rights have been violated? And how do we basically overturn qualified immunity?
I think you've got to do it through Congress, provided potentially something happens in November. I think that is where it needs to happen, because you're not going to get, the court has made jurisprudence, the court has precedent, and it is locked in. And the way the court's configured now, it's not going to change that. It would have to make a hard right turn. And even, let's say, potentially, just hypothetically, with a court, very rarely does the court make hard right turns to change their precedent, especially this line that they have built over qualified. You can think about, con law and some of your constitutional classes. I can name on like a few, like on one hand, times where the court has really made a completely turned face. And look how long it takes to happen. I think it would be easier for Congress to set up a use of force standard that they will use through the Department of Justice to say, if you want grant money from us, you must adopt this standard. And that happens all the time. That is all the time what happens. So you could have Congress come up with a law that says a lot of things in relation to policing. What is a viable use of force standard, and have the DOJ attach money to it as a policy-driven initiative. That's the first thing. The second thing is defining qualified immunity in a way that actually doesn't protect egregious, reckless misconduct. Clearly defining it. And what I would say in that situation, they need to get some serious attorneys in a room and write this statute in a way that's going to survive court challenges. You need to get some people who have been solicitor generals, some people who know how to deal with constitutional issues and can write it, because it's going to get challenged through the courts. So those are the two things I think at the base that you can talk about: a use of force policy that you would mandate anybody who got federal funds, which is most departments, to enact. And then two, to actually have a viable qualified immunity statute, because there's some situations where you need it. Let's be clear. But the way it is used now is not the way I think it was intended to be used. It is almost as high as the prosecutor's protection of absolute immunity.
The only thing I would add to this, and very briefly, is in the interim, short of reform of the type Professor Murphy's talking about, I think the national narrative that immunity does not equal exoneration, I'd like to see that take hold a little bit more. And I think to that end, in terms of empowering all of you, thinking about incremental reform in that space, because we have a lot of malfeasance I don't have to tell you, right? You've read the paper, you're in law school, you get it, you're here, we're having this important dialogue. But I do think there's a concern that we're wrapping up civil dismissal in lawsuits with, well, that behavior was okay. And I think there's something missing in the national conversation, that short of reform, rethinking the way we talk about officer behavior at a factual level is critical.
And so we have some questions from the group. The first one is, do you think it is feasible currently to get action legislatively through with the current law and order rhetoric that's been going on, or would this be more feasible with a different administration?
I think I think the law, if you do it correctly, qualified immunity, if it's done actually right, and not what we have through the Supreme Court as its dictate, it can work with law and order, because we do, let's be real, we want to be policed correctly. We all need police. I know sometimes I would like the police to actually protect and serve rather than punish and enslave. I really want to have them do their job. And I think this idea of law and order has been kind of co-opted in a way that is not, I think to me it's a policing it, but I get the rhetoric idea. And I think it does. I think there is a conversation that is continuing to be had, and you can see from the polling in this country that it's a conversation that many people are in support of. And, you know, I find it interesting when I was reading people's comments about Brad Pascal's, how dare they, this 6'8" white dude who's got all these guns and shooting guns out of his house and beating his wife gets taken down by SWAT. And I'm like, miraculously, he didn't get shot. Be happy he actually just got arrested. But let's say it's the 6'8" brother. We would be looking at, okay, obviously we need all the information because mysteriously the police reports look weird from the situation. But that's the issue of, we want proper policing. We want proper action. And I think that's the issue. And I push back on this law and order. It's a matter of doing your job correctly. You protect the entirety of your community, not just some folks. And again, I think, yes, I'm hoping there's a change in November, that we can start having these meaningful dialogues and actually see meaningful change, and at least starting to get some laws done. But again, I think we're already having this conversation in our communities. We're here, but also, across the country, there's support for this conversation.
Yeah, I would just chime in and add this on the law and order point. It's remarkable how history repeats itself. This is precisely what Nixon ran on stump speeches, campaigning to overrule Miranda. He packs the court with 4 justices. And not just, it's history repeating itself in terms of that tagline, but it's also citizens' willingness to accept that. We live in how many characters does Twitter allow? Like that's how we digest information now. We don't digest information on a nuanced basis. And the problem with saying, well, I'm tough on law and order is it's not just the points Professor Murphy quite rightly points out, which is the point of police to begin with. It's this willingness of society to assume just because the president says it means that's what he's thinking about, right? Because our willingness to accept that as binary is precisely the problem. But as her comments reveal, it's about the type of police force you want. And when we think about policing theory, about 3-ish decades ago, we moved away from community policing and into broken windows policing. I'm painting with a really broad brush here, but in many ways, the union of broken windows policing plus turning Terry v. Ohio on its head and making that code for proactive policing, the union of that math problem is just devastating. But I also strongly agree with Professor Murphy that lost in this conversation, it's not that we don't want police, right? That is, we don't seem to be having that conversation, right? So it's not about eliminating, and that there's a different question there on the defunding piece, which who knows if we'll have time for all of this, but that's not necessarily the point. Nobody's saying, hey, we don't need people to call on when we're hurt, injured, or there's an act of crime in progress. It's about how we police. And the law and order narrative just totally skips over all of that and panders to people who are willing to accept without nuance that that's in their best interest.
So we have another question from the group. If legislation was put in place to remove or reduce qualified immunity, would it likely or be possible that it could be expanded to Bivens actions so that recovery was more possible against federal actors as well? I know that's a long question, but you can also see it in the chat too.
They heard a lot from me earlier, Professor Murphy. I was ceding to you. I'm happy to do so here. I'm also happy to take a run at it.
Go ahead.
Well, I'll be brief. I think it's an intriguing question. I worry a little bit about displacing. I'm going to own my extreme interest in street policing at the state level. And so I want to just own that, and it'll contextualize my answer. I worry a little bit that would distract us from the highest best use of reform. I mean, when we think about the actors who interfere with and take our liberty, sure, FBI, ATF, et cetera, they have a role, and I don't want to undermine that. But I worry a little bit about, well, let's just try to accomplish the highest best thing here, which is about reforming at the state level, and the actors who take our liberty, arguably, well, not arguably, we can prove it with categorically less education, less training, and because we see the brain drain in policing. If the narrative is, if I could get the federal job, I would get it, right? And I wouldn't be in this job. And so I'll just close by saying I worry a little bit about trying to tackle too much here and conflating one thing with the other. That being said, I certainly wouldn't oppose thinking through federal actors, but I might also just close that I think because the training is better and because the expectations around federal prosecutions are a little bit different and the federal prosecutors handpick their cases, I guess I'm not as persuaded that that's an area, not that it doesn't need attention. I want to be careful in how I say this, but not in the manner of the kind of attention that the qualified immunity debate raises.
Okay, and the next question is, with the more recent case being Breonna Taylor that everyone knows about, we would like to know your thoughts on the use of grand juries in these type of situations, as well as the grand jury's decision not to charge officers for any harm to Breonna.
Oh, yes. Okay, so let me explain a little bit how grand juries work and why this insanity happens. Okay, so if you remember from your criminal procedure, for those of you who had it, grand juries are a prosecution construct. They're driven by a prosecutor. So the prosecutor impanels a grand jury in secret. Some states mandate a grand jury, like for example, New York has a grand jury system. Everything kind of runs through that. The federal government largely is a grand jury system. So what it is, obviously, is the prosecutor presenting charges to a grand jury for indictment. Okay, it's a probable cause determination to hold someone for charges. And the grand jury system has been used in these type of instances where their police have taken or murdered people in excessive use of force. So St. Louis County, St. Louis City did this all the time. And whenever there was a police murder of someone, they sent that thing to the grand jury, and miraculously, the grand jury would not indict. Now, let me just kind of give you an understanding. The saying that, a ham sandwich could be indicted by a grand jury is true. Okay, it is the only people there, the only attorney there is a prosecutor and the people. There's no defense attorney there. You don't get to know when it's happening. You don't get to cross-examine and all that stuff. It's just the prosecutor and whatever witnesses he or she calls, and the grand jurors who determine whether or not charges are brought. In Breonna Taylor's case, no, let me step back. In Mike Brown's case, okay, this is what happened. They brought it in St. Louis. They actually had the grand jury. When you read the transcript, what it read as is a actual defense case. It was very bizarre. And usually a prosecutor will only present as many witnesses as it has to substantiate the charges. They're not trying to try the case here because they know they're going to have to turn that grand jury transcript over to the defense sometimes in a criminal trial as you try your case. So they don't want to tip their hand. You're giving just enough to hold someone over for probable cause. That is not a high standard. In this situation, they would turn the system on its head and use it as a means to try the case without a defense attorney there, or actually there is no prosecutor because they're trying to justify the actions of the police. That's what happened in Mike Brown. In Breonna Taylor's case, the attorney general does one better, which I was surprised. I was like, I thought I had seen it all with how St. Louis did their craziness. He didn't bring any charges. Again, a prosecutor's job is to bring charges. The only charge, and I actually have to give credit to whoever this grand jury person was like, hold the phone here. I want to talk. And they were like, no, you can't. But it forced the attorney general to actually explain what happened. He only asked for one thing. Remember, the job of the prosecutor is to determine what charges are fitting a specific fact set, and then let the grand jury decide what they will. It was stunning to me to realize the only thing that you're charging with is the recklessness of somebody's house, but not actually the murders that went down in that apartment. So that's the issue. And there's nothing to do about that. There's really not, because that grand jury was impaneled to hear the situation. The only charge they got was the one they indicted on, which leads me to believe if they had been presented with other charges, they likely would have indicted, because that's usually what happens. The problem is the Kentucky Attorney General didn't want that. And that is, to me, the bigger question. Why did you not want to hold these officers responsible and let the chips fall where they may? If you remember what I said originally, in Wayne County, there was a situation very much like this. A little girl was asleep in her room in Detroit. It was a no-knock warrant. They went in, she got shot. The prosecution charged those officers with a slew of things and prosecuted the case. It got a mistrial the first time, they did it again. And I think that sent a message that we're serious about this. They charged it straight up like they did any other garden variety crime. It was an information, they had a preliminary hearing, and we're off to the races. This is why, in this situation, it is so different, where he's hiding behind this grand jury so he can hide potentially what is going on.
That was awesome. I really enjoyed that, selfishly. My contributions here, and I have to be a little careful, Byron, so I do honestly want you to cut me off. I have too much to say on this question, and I am going to try not to repeat anything Professor Murphy said. I want to start with, why are we here? I mean, it tugs a little bit in the thread of what she's emphasizing, but what was the point at the outset? I'm not clear on that. And I don't want that to be lost. Second, she says that she's right. The grand jury is a screening body in this posture that's being asked to evaluate probable cause. So why are we talking about self-defense? Why would you come out and say, and I want to be really clear about this in the press conference, we are barred from prosecuting. That gets an F in any class I teach, for the fundamental reason, apart from anything else I'm going to say, double jeopardy hasn't attached. Today, you could impanel a new grand jury right now and do everything that Professor Murphy's talking about. Bring the homicide charges, new grand jury, we're going to start over again. Lost in this narrative, and I don't know who counseled him. Forgive me for being so candid. I have strong feelings about this. But who counseled him to stand up in front of the world and say, we are barred? Have you lost your mind? You're not barred by anything. You're barred by you, maybe, which goes back to the question of, why did you put us through this to begin with? Because you're making the whole justice system for the rest of us who write, teach, think, and live this stuff every single day, making the rest of us look bad. So let me get off my soapbox and take you back into the self-defense problem here. At the risk of hurting your head, you'll recall that self-defense is a 1L concept for trial. It is an affirmative defense, and nobody's talking about this, but glad you're sitting down. It's not an element of a crime. I know that's shocking to hear. But she says probable cause is the basis for charging. All right, let's put that over here. When was the last time an affirmative defense went up against probable cause? And why aren't we having that conversation? So let's add into this mix. Some people might say, well, it's the prosecutor's ethical duty to put reasonable defenses in front of the grand jury. Okay, let's play with that, because we've seen that a little bit. I'm not saying I agree, but here's what I want you to question. Even if that's the case, you need to show me that that's how you do it in Kentucky, that that's how you do it every single day of the week, and not just when it's convenient to hide behind the grand jury, as Professor Murphy points out, but I'm talking about the routine people who you and I will never read about. And until you show me that, that argument carries absolutely no credibility for me. So I want to close with this, which is, there is the disconnect rather, between probable cause and an affirmative defense trial standard, But I want to close with, let's apply self-defense to this. So a lot of people say, well, the officers were executing a warrant. That belies the problems with the warrant. It encourages us to ignore that, and we don't have the kind of time, or maybe we do, it's up to you, Byron, in terms of the next question you want to ask, but the problems with this warrant are lost in the grand jury conversation. It's not binary. Hey, just because I have a warrant, I get to kick down your door and shoot you. That's not a thing. And if we don't focus on the magistrate who passed this warrant and the officers who wrote it as part of this conversation, then the reform facet outside the grand jury will be lost. But let's take it inside. Let's give credit to the warrant. Let's give credit to this idea of self-defense. The officers are still initial aggressors. Nobody's having that conversation, because think about who has the privilege of self-defense. It's the homeowner. So Kenneth Walker is there in his home. And the irony here is, for all of the folks who are pro-weapon, I need to protect my home, I'm not sure where they are in this conversation, but Kenneth Walker, it seems to me, factually did exactly what that facet of constituents would have people do, which is he shot. And on the law, he's permitted to do that because there's no duty to retreat in your own home. So as I analyze the facts, I don't see a place where he forfeited the privilege of self-defense. Instead, he retained it, and the officers never had it. So that's my best effort of brevity, Byron. I apologize if I went too long.
You're fine. So can we talk a little bit about the warrant they had, and why do you think that was not brought up whatsoever, since normally prosecutors overcharge and are kind of overzealous in getting the conviction, but even just getting it to court? Why do you think here it was so different? Do you think it was because it was the police officer, or there's a whole lot of variables?
Oh, you want to go first? You want me to go
please,
first?
Please. I insist. Yeah, go please.
Okay. So the problem is no-knock warrants as a construct, because that's what drove this. Is number one, the information that they relied on was wrong. This is a wrong location, and this is a danger with this type of warrant. Most warrants, you knock on the door, hi, we're the police, we have a warrant, we'd like to search your house. That would prevent the homeowner from knowing who is busting down my door. Again, I agree with Dean Gallini here as far as, where are the NRA folks in my Second Amendment right? Protect the home as your castle, and you can defend it. There's nothing, which I find interesting also. But again, like, these warrants are a problem in and of itself, and they should be phased out because there's too many of these situations happening in cities. The problem with this investigation is they're relying on bad information. And I hate to tell people, this stuff happens all the time. I can't tell you how many cases I have seen in my 20 plus years, and that makes me cry, of doing this criminal defense, of seeing warrants that are just bad, based on bad information, based on bad facts, bad addresses, et cetera, et cetera, et cetera. Now, there are some, the Supreme Court has bent over backwards to, well, they make mistakes. It's hard being the police. It's hard being the person in the house when you're scared to death and people are coming in your home. And it's SWAT, and it's not just an officer. Let's be real here. This was SWAT at their door. Let's just pause. That's SWAT. Coming in like this is truly, and this goes to my other issue of how we have militarized the police to the nth degree. But I will leave that alone for a second to talk about, why is SWAT at this house, at this apartment? This is an apartment building. This isn't a residential house that has some kind of area around it. You know that there are other people in these houses where you have SWAT. And nobody took a moment to step back and think about the logistics of this. And that is a problem. This is, again, problems with the chain of command of a police department. Who is the commanding officer? There were people who had to make decisions for this event to happen. And that is where I'm like, where are the rest of you who decided that this was how we were going to police this incident, this specific crime? And how did you get it so wrong? What was the harm at this point to knocking on the door and saying, hi, this is the police. We have a warrant. Can you open the door? Can we talk about this? Versus just busting down the door, freaking everybody out, and then putting the neighbors at risk, which is what you had. Why are they getting bullets through their door, through their walls? Because again, it's an apartment complex. This is my issue with this situation as far as I look at the facts of it on the ground. How does this happen? Who is found? Like, look, think about all the officers who fell down on the job to get to this situation. You've got bad information, a warrant, and it is really not hard. Let's be realistic. It's not hard to get a warrant. The officers know which judges are going to sign pretty much anything that they put in front of them versus the judges who are actually going to ask questions. And that's an issue. I've had warrants where I'm like, why did you sign this? This isn't even valid on its face. But the judge obviously didn't read it. And that's a problem. These are some of the issues in the system that lead to these kind of issues.
So in Crim Pro, we talk about the big four for warrants. So particularity, magistrate has to be neutral and detached, got to have probable cause, and there's got to be an oath or affirmation. I want to tug on two of those threads. So particularity, one of the things that maybe some of you know is that this same detective got 4 other warrants on boilerplate language within 15 minutes, all signed by the same magistrate. I'm not sure where the particularity is there. And so we need to be thinking about the magistrate as rubber stamp and the concern about this idea of being independent and detached. I'm not sure that happened here, right? So that's one. Professor Murphy makes a really important observation around, well, what precluded you from just knocking on the door? Well, let's pull that thread just a little bit more. What did they want? They wanted to investigate drug trafficking, right? Well, here's a little bit more of the money ball on that. They knew about the drug trafficking because they had a poll camera that was investigating this apartment complex. So they knew and by the way, you might be wondering, well, why was Breonna Taylor listed? For those of you who have looked, why was she listed on the warrant? She was on a red Dodge Charger that was subject to search. She was on that. It wasn't that she was a subject of the investigation. That's been a little lost in the narrative, and I want it to be clear. She simply had an ownership interest in the vehicle to be searched. Putting that aside, the point is this: these were not people who were going anywhere, right? So it's not just about the fact that you are disrupting this neighborhood over a drug offense. And please don't hear me as saying I'm undermining the nature of drugs we need to enforce, investigate, et cetera. It's, to Professor Murphy's point, how we do that. And so I would just emphasize also, these, and it won't shock you to know, we're not the most intelligent drug traffickers. They had these people on camera for weeks on end. So I just, at a very basic and high level question, what's the point? They weren't going anywhere. They were going to wake up the next morning. They were going to use the same cars you've been watching. They were going to drive to a predetermined location. There were about 1 million other ways to execute this investigation safely. So, and I would just close on the no knock piece of this. I know there's a lot of factual debate about, whether officers knocked or not, and that has emerged in the conversation. I just would, for this group, have you think about 2 things. One, the Supreme Court several years back removed the exclusionary rule from attachment to knock and announce, or stated differently, it is not a 4th Amendment violation that is subject to exclusion if I fail to knock and announce. So we should be a little skeptical about the role that plays in day-to-day policing. And then just number 2, I would also ask you to think about the difference between, let's assume there was a knock and announce, the difference between doing it and giving time for the homeowner to respond. Right, so this police kick down door is very different from knock, police, wait a period, and then get the battering ram out. And by the way, that's what they used, right? And we're not having that temporal conversation about how long we gave the homeowner to respond.
As we're closing in on the end of this, I would just like to have your general thoughts on the current racial unrest, as well as qualified immunity, or other things that you want to hit on before we got off this call.
I will just say I am glad to see the protesting. It it also saddened me. I had a conversation with my mother, who I will not reveal her age because she may, even though she is still in Michigan, will come and kill me. Um, but my family's from Alabama. I think that can kind of say it. And when I talked to her about all of the protests, this, Floyd, everything, she was very disheartened because she said, I thought we had fought this fight and we were past this. And it hurt to hear her so sad. But I do think she was heartened to see that it was a much more diverse group of people marching than what she had been experiencing growing up in Alabama. And I will say it actually gave me hope. And I'm a very cynical person, for those of you who know me. That it gave me hope that we actually can affect change. We've had to, like, we've brought, things have happened. I was actually very surprised that Breonna Taylor's family got paid without really even mounting up and filing a civil suit. And I was glad that their settlement also stated the fact of changing the police department. That actually gave me, like, okay, you understand that this can be used. This is horrific. This is wrong. That this desires justice. But that family decided, we're going to try to make this better so no one else has experienced the pain that we feel. So I will say it heartens me. And as I am now realizing I'm no longer young, which hurts, y'all are the future of this. You guys are the ones who are going to have to hold the mantle now. I'm getting a little too young to do the march. Too old to do the marching. So, like, you guys are the future of this movement. You will be the politicians. You will be the councilmen, the representatives. You will be the judges. This is your moment too, to push for change. And I will say, the one thing I think that you also need to think about as we think about changing this narrative, and I am from Detroit, a union town. The police unions have to go. I understand the point of a police union, but the police unions have been the blue line, where there has been no movement of officers who are egregious, and they know who they are, and they will protect them to no end. And I say that, and it saddens me because, again, I do believe in unions. I do think that they serve a really serious point, but I am concerned about how the unions can no longer recognize that they have to be a check on themselves.
I would leave you with 3 very short thoughts, one of which is the world needs you. Think about what you're doing right now. This is a group that's dedicating free time to have this conversation, to invest in trying to push to learn more. And my charge to you, because you are willing to do that, is you need to find out where you can make an impact. And you have got to put the blinders on when you do that. There's a lot of noise out there. There's going to be a lot of distraction, and there's going to be a lot of interference that precludes you from finding where you can make that impact. And I want you to answer the passion question. What are you passionate about in this conversation? And reverse engineer back. While you do that, blinders up. 2, as you think about that, the world needs problem solvers, not issue spotters. If you're spotting the issue, it's too late, right? We need solution-based lawyers. We don't need this to get to an appellate opinion. So thinking on the front end proactively rather than on the back end reactively is thought number 2. And my third and final thought for you is composure equals credibility. There is a lot of divisiveness on every side of these conversations. They're charged in legal ways, in political ways, in human ways. But if you've seen the movie Hitch, right? Yeah, you live there, right? We don't need to do any of this. We don't need to do any of that. You know where I'm talking about. You know the scene I'm talking about. Because your composure will bring credibility to this conversation in a way that if we lean one side or too much, the emotion will lead and the substance will not. So let me thank you for all. It's so much fun to be with all of you, and I just really appreciate it. It's great to see you. Thank you, Jonathan, for the invite. Thank you, Byron, for your thoughtful questions, and thank you for Professor Murphy for leading a great discussion and helping me limp along with you.
So with that being said, we thank you all for donating your time, and we really appreciate all the valuable insights as well as knowledge that you've given us today, and that will conclude this event. Thank you.